What's up, everybody? We are back at it here with more Brian Kohberger documents. And we're going to talk about the state objecting to the defendant's second motion to stay, the beef they have with the defendant trying to stay the case again, and did they actually admit an error in their process, even a small one that is not substantial. We're going to read through that document together, discuss it, see what they think of the defendant's arguments, see if they think any hold water, and of course, answer all the questions you have about this document, and any other Brian Kohberger questions. I've also gotten a lot of questions about a couple of other things, content-wise and other, that if we need a break from the document, we'll talk about them, or maybe I'll talk about them at the end of the video. But thank you, everybody, for joining me. Hit that like button if you haven't already. And subscribe to our page for more content like this. So let's jump into this objection and see what the state's arguing, see how you all feel about it. I know how I feel about it. But this is the objection to the defendant's second motion to stay proceedings. We have to remember the context of this. The judge has already granted a 37-day stay. The state was frustrated with it. Both sides are basically accusing the other of making it more difficult to try this case within the 6-month speedy trial period. So that's, for anybody to decide how they feel about that and which side they think is actually wasting time. I think both sides are probably doing their job at this point. The defense is making all the arguments, protecting all the arguments, protecting the record, asking for all the documents they think are necessary. And the state's only turning over documents they think are actually discoverable. So is the state going too far in objecting to discovery and delaying the case? I haven't felt that way so far, but I do think that they have objected to a bunch of discovery materials that have ended up being something they needed to turn over, or the judge ordering them to give it to the defense. So I think if the defense has an argument on any delay, it would be there. And the state just continuously kind of rolls their eyes at some of the defense's arguments, some rightfully so. We'll see if that is what is in today's document. So comes now, State of Idaho, by and through the Latah County prosecuting attorney, and objects the defendant's second motion to stay proceedings because the defendant has not factually asserted a substantial failure to comply with the Uniform Jury Selection and Service Act. His motion should be denied. So a substantial failure. So in this document, will they admit that there are some minor failures? And if there are minor failures, now it just becomes a discretionary decision. What's minor versus substantial? And what guidance do we have in making that determination? Before ever reviewing any grand jury materials to determine whether a violation of Idaho's Uniform Jury Selection and Service Act had actually occurred, the defendant was determined to obtain a stay in this case. And so he filed his first motion to stay under Idaho Code 2213 without knowing whether or not he had any basis in law or fact to make such a request. The defendant asked the court to grind the litigation of this matter to a halt because he intended to contest the indictment. So, good argument. Thought it was a good argument the first time around. The flaw in their argument, the fly in their ointment, right? I think that's a thing, is that the judge granted that stay. So you can't roll your eyes too hard at something the defense did if it worked, because the judge at least agreed with something that the defense made, some argument the defense made in that first motion to stay, and desired to discover the grounds upon which to file a motion to dismiss related to how the grand jury was selected. The court declined to grant relief under that subsection and instead issued a limited stay ordering that speedy trial be told for a period of 37 days. The state has moved to reconsider that order, and argument is set for August 18th, 2023, which is later this week. So people are going to say the judge did not grant that motion. Sure, that is correct. Technically, the judge did not grant that motion. But even without having the grand jury transcripts, the defense wanted a stay, and they got a stay. So this is where we get into semantics of, did a judge grant or deny a motion, but what relief was actually granted and what relief was requested? Because in that case, they requested a stay, they got a stay. Having now reviewed the grand jury material, that's like saying, I asked the jury for $1 million because I felt like my client needed a lot of medical treatment in the future, and those are for future medical bills. Jury declined to give anything for future medical bills, but they gave $1 million in pain and suffering. Well, guess what? They still gave $1 million. So why they got to the outcome I wanted is not as important as getting the outcome that we thought was fair. In that trial, that's never happened, but I'm just giving it as an example. Or in this case, the defense, they got the outcome they felt was fair and just, which was a stay. Having now reviewed the grand jury materials provided since his initial motion, the defendant has delivered on his promised strategy. He seeks a stay to buy more time to challenge the indictment in this case. In support of his second motion to stay, the defendant submitted the affidavit of Ann Taylor, filed under seal. Through the affidavit, the defendant argues for a stay relying solely on Idaho Code 2208 and 2213. This motion, like the last, should be denied. Well, should it be denied in the same way where the court does grant a small stay? I don't think the state would be happy about that. What else is interesting about this is they don't really mention the whole burden of proof argument that the defendant made in the motion to dismiss the indictment. That motion to dismiss, I think, was made before they actually got the grand jury materials, which was weird, right? That timeline's kind of weird. I need more on that. But again, we'll hear more about that, I'm sure, in future documents. But they do want to file more motions to dismiss, it sounds like, based on other things from the transcripts and materials from the grand jury. Argument. The defendant's allegations regarding juror bias and statements of the court during jury selection process do not fall within the scope of the Uniform Jury Selection and Service Act. The Uniform Jury Selection and Service Act is concerned with the procedural mechanisms put in place by the courts in selecting grand and trial juries. Specifically, the purpose of the act is to ensure that all persons selected for jury service be selected at random from a fair cross-section of the population of the area served by the court, and that all qualified citizens have the opportunity, in accordance with this act, to be considered for jury service in the state and an obligation to serve as jurors when summoned for that purpose. To that end, the act prohibits discrimination against jurors on the basis of race, color, religion, sex, national origin, or economic status. And it establishes the process for appointment of jury commissioner and the process of reimbursing the jury commissioner for travel and other expenses, establishes the procedure by which the jury lists are compiled and maintained, sets forth a procedure by which the court must update those jury lists, establishes the procedure for the courts to issue juror questionnaires and summonses, and sets forth other processes and procedures to ensure the grand jury and trial jury are fairly selected from a reasonable cross-section of the community. The act does not address, nor does it provide a remedy for, individual juror bias or statements made by the court during the jury selection process. Thus, to the extent that the defendant's concerns are based on such allegations, such issues fall outside the scope of the act and cannot form a basis for the stay the defendant seeks. So once again, a procedural technical argument here in response by the state that basically says, and this is kind of an additional argument here, is that even if, because we're going to go through the fact that the state actually doesn't think they made any errors, okay? They don't think they made any errors, but even if they did, it doesn't fall within this act, and we're going to hear them later argue it was not a substantial error. So whenever you can win the argument by saying, even if what they're saying is right, Judge, we still win, usually that's a pretty good spot to be in. Let's answer a couple questions here. Alicia, love all the content. It helps so much with my current law studies. Shout out from Pittsburgh. That's awesome, Alicia. Suzanne, Peter, do you think that a lot of these unusual legal documents are coming from Kohberger himself because he thinks he's such a legal scholar? No, I could be wrong. He could be involved in the process, but I think his lawyers are carrying most of the weight when it comes to really making these legal arguments, making these decisions, determining what they're going to put in these motions. I think the vast majority of that is coming from his lawyers. I think they're trying to find some novel legal arguments. Now, this is a response by the state. So the state is the one drafting this document, but they are responding to a lot of what the defendant said. Okay. The defendant's allegations regarding the exclusion of clerical information on some of the questionnaires do not fall within the scope of the act. The defendant asserts that the court-issued questionnaires constitute a failure of mechanism in drawing a grand jury pool. In support of this argument, the defendant asserts that some of the questionnaires do not include certain numerical information at the top of the page. However, the information referenced by the defendant is not required by the act. Further, this information is not even included in the model form promulgated by the Idaho Supreme Court. Okay, and they have a model juror qualification questionnaire form that does not include the information referenced by the defendant. Thus, this issue also falls totally outside the scope of the act. So let me just give you an idea of what they're saying here. This is a technicality. This may be something that they have found some argument should be included on the form, but they are so wrong about this that when the Supreme Court gives us the form to start from, coming up with a jury questionnaire, it's not even included there. So basically what they're arguing is the Supreme Court is also wrong. And they want this lower level court to look at the Supreme Court forms and say those forms are wrong. Now, could this happen? Yes. Could this be the way changes get made to their forms and samples that they use in their state? Yes. Is it likely? No. Usually an argument like this has a next to 0% chance of being successful. It's like when people object to, like in our case, sometimes they object to standard jury instructions. Sometimes they object to the standard jury verdict form. It's like, that's fine, and we can come up with a better one, but there's nothing legally wrong usually about the standard form unless something a lawyer adds to it is wrong. Defendant's suggestion that the court should maintain separate qualified juror lists for grand juries and trial juries misreads the plain language of the Idaho Code. Through Ms. Taylor's affidavit, the defendant argues that Idaho Code 2208 states that individuals must be randomly drawn from a county list and that the jury commissioner shall draw a requisite number of qualified jurors for one or more panels or for a grand jury. Thus, the defense asserts the panel was improperly brought in as a grand jury. Later, the defense again points out that the language of the statute uses the word or between jury panels and a grand jury panel. This is a misreading of the plain language of the statute. So let's read it. The court or any other state or county official having authority to conduct a trial or hearing with a jury within the county may direct the jury commissioner to draw and assign to that court or official the number of qualified jurors deemed necessary for one or more grand jury panels or as required by law for a grand jury. Upon receipt of the direction and in a manner prescribed by the court, the jury commission shall publicly draw at random by use of a manual, mechanical, or automated system from the county jury list the number of prospective jurors specified. Plainly, the word or appears because the requisite number of jurors for a misdemeanor, felony, or civil trial jury is not always the same as the requisite number for a grand jury. Nothing in the act requires the courts to maintain separate lists for grand or trial juries. The court should decline to entertain this misreading of the act. Again, plain language here, I see it the same way the state does. I don't see it the same way that Kohberger's team does. Additionally, what else do they have on their side? Well, Judge, let's go back. The defense is making an argument here that they need to have a separate list for grand juries. Well, we've done grand juries in this state. Is that how they always do it? Do they always pull from a separate list? Or has this statute always been read the way the state is saying? That they're talking about or based on other cases and potential, the potential number of jurors that happen in these other cases. So again, I don't want to say that things cannot change, that ground cannot be broken, but that is the exception in the law, not the rule. So to change years and years of doing things a certain way and calling them unconstitutional, calling them wrong, is more unusual than you may think, especially in the law. All right, let's take another quick break here. Kurt from Uncivil Law. This super chat is an overt act in furtherance of a conspiracy. I am not sure what the conspiracy is, but I look forward to Georgia letting me know. I think this is a Trump joke. So if you want that content, I think Kurt's probably hitting it. I stay out of politics as much as possible. I think Kurt dives into them. I'm sure he'll let you know in the chat if he does. Alicia, thank you so much for the super sticker. And welcome to a few new members here. Kim and Stacy K. And Janet, thanks for the super sticker. There was a question I wanted to grab here and I just lost it. All right. We'll get back to this. All right. All right, D. As to the remainder of the defendant's allegations, he has not alleged a substantial failure to comply with the act, even if defendant can factually establish that a violation has occurred. And I think what they're talking about here is like numbers being missed on a page, or some technical thing that was wrong but didn't matter and didn't change the outcome. We shouldn't waste everybody's time and money and resources that should be spent on other cases doing this all over again if it is not a substantial error or substantial failure to comply. That's the point of that language being in the law. Some lay people complain about things like that in the law, like it gives too much discretion to courts or to lawyers. It's not black and white. It's not easy. It's not shall or shall not do something where we can just say, okay, this happened or it didn't happen. But let's say they put page number 2 on the second page and page number 2 on the third page and page number 3 on the second page. Did that matter? Now, if it's something that they have to read in order and it could be misleading if it's read out of order, then potentially it could be a substantial failure to comply. And as you can see, as I'm going through my different analogies, I can pick apart my own analogies. That's what lawyers do. But the point is, you have to make a legitimate argument why that failure was substantial and was potentially difference making. And here they argue that the defendant has not met his burden of demonstrating a substantial failure to comply with the act. Instead, the defendant asked the court to enter a stay in the case by raising allegations of technical violations without ever explaining how any of those technical violations reach the substantial standard set forth in the statute, apparently inviting the court to apply a strict liability standard. But the act does not sweep so broadly. Only a substantial failure to comply can trigger a stay. Upon motion filed under this subsection of this section containing a sworn statement of facts, which, if true, would constitute a substantial failure to comply with this chapter, the moving party is entitled to present in support of the motion the testimony of the jury commissioner or the clerk, any relevant records and papers not public or otherwise available used by the jury commissioner or the clerk, and any other relevant evidence. If the court determines that in selecting either a grand jury or trial jury, there has been a substantial failure to comply with this chapter, the court shall stay the proceedings pending the selection of the jury in conformity with this chapter, quash an indictment, or grant other appropriate relief. So that's why in the beginning they set out what the act actually says, and then they go through where the errors are, and we determine whether or not that error was substantial, which again is within the judge's discretion to determine. Thus, to obtain a stay, the defendant cannot merely allege that a violation occurred. Again, some people can read into this, and I kind of got some questions. Are the state admitting that they made some minor violations? Because any violation of the defendant's rights to a fair trial is a big deal. And I agree, except when the law and the statute says otherwise, if it is just a page number or something like that. Now, it's very different than getting a date wrong or getting a name wrong. Those are very important issues. Those are substantial. But if it was not substantial, then I do think that in this case, the stay should not be granted. The indictment should not be quashed. Setting aside the claims of juror bias and missing numerical information on the questionnaire forms that fall wholly outside of the scope of the act, the court has before it 3 issues related to the questionnaires. First, that one of the grand jurors marked the box indicating they do not comprehend English. That could be substantial. There's an error that absolutely could be substantial. Second, that one of the grand jurors disclosed that they were a prior criminal defendant. And third, that one of the grand jurors did not mark whether or not they were a prior criminal defendant and did not sign and affirm the truth of responses. So that's interesting. They're not signing affirm the truth of the responses. That's kind of just annoying how they would miss something like that. Being a prior criminal defendant, unless they're going to correct me in the rest of this motion, that doesn't mean you can't be a juror. In most states, you can't be a felon, a convicted felon, and be a juror, at least for a period of time. But just being a criminal defendant, if it was not guilty or the charges were dismissed, you can still be a juror. The court should dismiss out of hand the argument related to prior criminal history, because being a prior criminal defendant does not preclude somebody from sitting on the grand jury. I guess I should keep reading before we get there, right? Setting forth the qualification questionnaire requirements. Instead, only those with a felony criminal conviction are disqualified from serving on a grand jury. Thus, the allegation falls outside the scope of the act altogether. Okay. Sorry, I didn't realize that was literally coming up as I was saying it. The final 2 allegations concern the duty of the courts to follow up when a juror is not qualified to serve or when a questionnaire is not fully completed. The administrative district judge or administrative district judge's designee, upon request or on its own initiative, shall determine on the basis of information provided on the questionnaire whether a juror is disqualified. If it appears that there is an omission, the clerk or the jury commissioner shall again send forth the form with instructions to make the necessary addition. Defendant alleges that one of the grand jurors submitted an incomplete questionnaire and suggests that this somehow violated the act. But The submission of an incomplete form is not a violation of the Act. In fact, the Act contemplates that incomplete forms will be submitted, in which case the statute requires only that a jury commissioner again send the form with instructions to prospective jurors to make necessary addition, clarification, or correction, and to return the form to the jury commission within 10 days after its second mailing. Notably, the statute requires no additional follow-up after the jury commissioner simply sends out the form a second time. That means there are only two problems with the defendant's incomplete theory. First, just as with the checkbox and allegation above, the defendant's affidavit does not even allege whether the commissioner failed to follow this process in response to the incomplete questionnaires, and thus the defendant is not entitled to the stay. So basically they're saying you don't even have to actually correct the form. The law just says send it out again with instructions. Now, while I agreed with the state's reading of a different part of the statute, I disagree with this. I think the point is we've got to get accurate information and full information. This potentially is different than just a page number that's different. And it sounds like the state's saying, well, they're saying he just had to follow up. And did they follow up or did they not? We don't know, but the defendant didn't allege it. And they're right there, I guess, that the defendant doesn't even know if the process was followed appropriately. This statute requires for a stay a sworn statement of facts, which, if true, would constitute a substantial failure to comply with this chapter. So they have that burden to prove it. The defense has that burden. Second, even if that allegation has been made, the jury commissioner's mere failure to conduct a ministerial task of sending the questionnaire out a second time cannot accurately be described as a substantial failure to comply with the statute. So I think this could go either way. If there was a mistake or something omitted that could have been important and they didn't follow the procedure of following up, I think that could potentially be a substantial failure to comply, which is why it's important to have all the details and be able to present this to the court. And so I guess my next question would be, why doesn't the defense have this information? Did they just miss it? Do they not have it yet? Are they waiting for it? Those are all important factors in this analysis for the judge. As to the allegation that a grand juror checked the box indicating that he or she did not comprehend the English language, that's important. It is entirely accurate that an individual who actually cannot comprehend the English language is not qualified to sit on a grand jury. Well, yeah, I'm glad we're all in agreement there. Setting forth the requirement that jurors read, speak, and understand the English language. And the Act provides a process by which the court may determine the qualification of grand jurors either upon request or upon its own initiative. So also, something that we should all understand through this process. This is why criminal defense attorneys are so important. Let's say somebody checks a box that I can't understand English, and it's just the prosecutor. And the prosecutor's like, well, we don't really care because, and I'll just tell you what the research says. If someone either doesn't understand English or doesn't have a comprehension level that has the ability to read documents and make decisions based on those documents, whether it be for a million different reasons, but let's just go with not being able to speak English at this point. The research shows they are much more likely to go with whatever the majority wants and not actually, use their own vote as their own voice. So that's why criminal defendants will sometimes dig into this more. Now, sometimes criminal defense lawyers, I said criminal defendants, I should have said criminal defense lawyers. Sometimes criminal defense lawyers also, if they feel like they've got a good jury, maybe they won't mind to have somebody else on there that's just going to go with whatever the majority is. So that really is part of the discussion here, but I think just about every lawyer would think it was a big deal if a juror could not understand the English language. That this grand juror was presumably able to otherwise complete the questionnaire form entirely in English and to participate in the grand jury proceedings demonstrates that the individual merely checked the wrong box of a lengthy form. So, here are some issues I have with this sentence. That the juror was presumably able to otherwise complete the questionnaire. So, we haven't seen the questionnaire, obviously, and rightfully so. It is sealed. But they said he or she presumably completed the questionnaire. And I would think they have this information because the state is privy to these documents. And I think they would have or should have said if they did read the questionnaire that was completed and this was an obvious mistake, they should have said, The juror was able to. The juror did complete the questionnaire without any issue. The juror wrote in English. The juror's answers were correct in responding to the questions written in English. But the word presumably in there throws me off a little bit. Number one. Number two, if this juror did in fact answer the questionnaire perfectly fine and their name is John Smith and they, have worked for USPS for 20 years and they're retired and their wife is in law enforcement and they have 6 kids and they were able to write all of that out in English and explain it all in English. And again, responding to questions in English. And the defense made this argument as if they couldn't speak English because they clicked the wrong box. That is an argument. I don't fault them for bringing it up, but they had to know they were going to lose. Again, back in the day, it may correspond with, clicking the wrong gender or writing down 25 instead of 52. We've had those issues about how old somebody is. So there can be clerical errors and some of them can be a big deal. But if the rest of the form can show that this was clearly just you checked the wrong box, it's not going to make a difference in the outcome and not going to be considered a substantial error. More importantly, however, the defense does not even allege that the administrative district court judge or designee failed to follow up on this particular questionnaire. Thus, the defendant has not alleged any violation of the act, let alone a substantial one. So once again, saying that this problem is here is not enough, according to the state's argument. They had to allege that they also did not follow up properly with the procedures that they should have. Now, one of the reasons the judge or prosecutor or anybody talking to this grand jury, one of the reasons they probably didn't follow up on this, or maybe one of the reasons they didn't follow up on this, is this person answered questions throughout. We have a transcript, right, of jury selection. Did this juror answer questions in English and understand the questions in English to prove that this was just a mistake? If so, a waste of our time to even consider this argument. Conclusion. Most of the allegations submitted by the defendant fall entirely outside of the Uniform Jury Selection and Service Act. The few that remain do not factually allege a substantial failure. So once again, the few that remain, are they admitting any even minor failures or errors to comply with the act? The court should decline to indulge the defendant's already stated intention to buy more time to engage in various litigation strategies. This motion, like the last, should be denied. Okay? So, this is an argument I think the defense is making to try and get more time to fight this. I think that this was not the strongest of arguments made. I think that potentially when they have a chance to go through and really dissect all of the grand jury documents and materials, maybe they'll find something more. But we really haven't seen any groundbreaking argument by the defense that something went wrong through these proceedings, in my opinion, that I've seen from documents I've looked at. All right, let's get to some questions here. Netwoman, what is the difference between a grand jury and a special grand jury? Also, I thought that grand jury served for a year. Is that a state difference? Thank you again for all of the lives, premieres, and shorts. Great content. So different jurisdictions do it differently on how the grand juries serve, how long they serve, what the purpose of them are. We talked about it a little bit with my dad where we really dove into grand juries specifically. So I will say check that video out if you want the deep dive on it. But special grand juries are usually ones called for specific cases and they just handle one case. Other grand juries can make decisions in lots of cases or be an investigative grand jury like we heard out of Pennsylvania. Kirsty, is there a limit to the number of stays that can be granted? Will the judge see this as trying to extend without waiving speedy trial? So the judge may have, everybody in the process may have a benefit from granting short stays so that we still don't delay this trial forever. Because once they waive speedy, once you start granting continuances, then it can take years for a case to go to trial. So I don't see this as necessarily a negative that you're asking for more stays if there are legitimate reasons, but I do think the judge does not want to set the precedent of just continuing to grant 30-day stays to the defense. Stephanie, Question: do judges know all of these motions are going to be filed? What I mean is, does a judge say, oh, I am going to get a lot of motions over this one? Hope you understand my question. So sometimes judges know my ruling is going to um, uh, be responded with a bunch of motions, a motion to reconsider. But most of the time, the judge doesn't know what's in all the grand jury materials, what's in the discovery, what they're asking for until it comes before them. So they don't always anticipate motions. Now, motions to dismiss happen all the time, and the motions for summary judgment, they expect those, but they don't necessarily know what the discovery disputes are going to be. Unsolved crimes, prosecution admitting, big no-no. Yes, very unusual for them to do that. Karen, you're so funny on double speed, I couldn't keep up. Yeah, I kind of just go on double speed or 1.5 speed maybe as my natural speed. Jose Ramirez, will you be covering the FBG duck case in October? I don't know what that is, so you'll have to give me more context. Why is everyone being so mean on here? Please listen before you speak. So I don't know why people are being mean. Usually the chat is pretty great in sharing their opinions respectfully. I don't mind disagreement, but yeah, let's try to keep it cordial, professional, respectful. Even if you want to disagree, it's totally cool to disagree. Mercury, do lawyers create checklists of things like this to go through? So sometimes on certain cases, but not usually. Every case is its own individual thing. And so you do the research on whatever the issues are in that case. And if you find issues, then you apply them to the statute, and that's how you write your motions. It's not just like, oh, I mean, sometimes if you do a lot of DUIs, let's say, okay, did the cop do this? Did they check for this? What does their report say about that? Why were they pulled over? Were there any witnesses? Did they do it on flat land? If they did field sobriety exercises, did they read them the right instructions? So there are certain cases that are just the same every time. But when you have bigger cases or more complex cases or federal cases, it's not just a checklist and the same investigation that you do every time as a lawyer. Azam, hey, lawyer, fam. Thanks for the love yesterday. I'm so sorry I missed the live. I slept through my alarm. You deserve it, as Azam, once in a while, Haha, I made it today. Yay. Question: what would happen if these motions continued until the trial date? My guess is the defense is going to say we couldn't adequately prepare for the trial within the speedy trial time. Therefore, motion to dismiss based on speedy trial, violation of speedy trial. And the judge can say, nope, you can either try it within this 6 months and 37 days, or you can waive your right to speedy trial and continue it if you really think you need more time. The state's ready to go. And they say they've given you everything. Now we can go to trial and you can use it as an appellate issue, which is probably what's going to happen. But Sammy, what about the blindside Michael Orr case? So I've done a couple of shorts and reels on this on Instagram and then on our Lawyer in Shorts channel. But this is going to be one that we have to see how it all comes out, because Michael Orr has filed some things in the past, and he's filed something now with the probate court saying it's a unlawful conservatorship. He was tricked into. Basically, he wants punitive damages. He wants money back for his life story, things like that. The Toohey family are saying we didn't even make that much money off of it. I don't know what he's talking about. We've had a good relationship and he's done this. He's asked us for money kind of multiple times. We still love Michael. We still want the best for him. So I don't really know at this point. I think we need to see more of what happened. It seems like everybody agrees it was a conservatorship, but was it agreed on, or was he tricked into signing it thinking it was actually adoption papers? He was over 18, but a lot of people don't understand the process. That's kind of the point of this channel. So people understand their rights, processes, when they need lawyers, when they should seek legal counsel, things like that. Nikki B got gifted a membership. Yes, that is awesome, Nikki. Congratulations. And speaking of members, we are about to post in the members only community page our fantasy football league for this year. That post will be going up this week, and we will be drafting either next week or the week after. I'm going to put the date in the post, and do not sign up for the league unless you can be there for the draft live while it's happening. It'll be online, so you can do it anywhere in the world, but make sure you are there. And I want to get people from every membership tier, so we're going to post it per tiers so that we can get everybody that we can in there. It's either going to be a 12 or 14 team league. So that'll be fun for everybody that loves fantasy football. Additionally, I've gotten a lot of questions, and I saw Emily Baker was doing them, and Ian Runkle of the Bailey was doing the Johnny Depp like sidebar transcripts. So I don't really have a ton of interest in just reading transcripts of the trial, but the sidebars are interesting and something that we didn't hear and didn't see. So if you guys are interested in anything to do with that, let me know. You can let me know on Twitter, on Instagram. You can send me the transcripts. I haven't seen them yet. I don't know where to access them. I don't know if they're easily posted online or if I got to go pay for them and order them. If I do, I can, if you guys are interested in it. So just let me know if you're interested in it. And people are asking how to get memberships. There's a join button in the bottom. And we do just, you don't have to, never feel like you have to join the membership. Just random perks like a fantasy football league or certain videos and things like that for members only, just like extra perks. And we don't do any of the legal stuff on there. No case breakdowns. You're not missing any of that because the point of this channel is that to do the case breakdowns, to give you as much information and value as you could possibly get out of learning your rights in the legal process. But yeah, so let me know about the depth transcripts if it's something you're interested in. If not, we will not do them. And then keep an eye out for the fantasy football stuff. I will answer a couple more questions before we go here. People asking, how many of these motions do you expect? Honestly, you can't really number the motions because we are not seeing the arguments that they're having. Remember Johnny and Amber, and we read some of their motions to compel. It happens in every case where you disagree on what's going to happen in discovery. When we have experts, my guess will be that each side will argue about the expertise and whether they rise to a level of an expert or whether they should even be able to call this person as an expert, whether they're testifying to anything that a lay person cannot understand on their own. So I expect to have a lot more motions, a lot more arguments, a lot more hearings. Rebecca said she's gifting memberships specifically for the fantasy football league, specifically for that fantasy football league. Yes, Rebecca is one of the main components pushing for it. So we will make sure that we have a spot for Rebecca in our fantasy football league. So John, write that down. She's gifted a bunch of memberships to give people the chance to join the fantasy football league as well. Marissa, I sent you an email for info about how your channel helps us as jurors. I hope it helps with your presentation you mentioned before. Thank you, Marissa. Yes, I am presenting to a panel of criminal defense attorneys. Actually, not a panel. The entire group in our county of criminal defense attorneys asked me to come and talk about YouTube and social media and how it's affecting trials and the media in general, kind of like our podcast series, Trial by Media. They want to know about it. They want to know how it affects witnesses, parties, how the public looks at criminal defendants and jurors. And Marissa gave me some great insight when she was a juror recently on that experience. Thank you, Rebecca, again for the super sticker. LL Fool J. Peter, are you planning on covering the Robin Niceta case in Colorado? Again, most of the time, until I'm covering the cases, I don't really know much about the cases. I don't know who Robin Niceta is. I have not seen anything about the case. So as with all content here, if you all are interested in this case, let me know. Shoot me messages and DMs on social media. When we do polls on the community page, vote for that case. All right. That is all we've got for today. Thank you so much, everybody who joined us. As always, you guys make the content so much better here. Please hit that like button on your way out if you haven't already. Let's get this video to 3,000 likes before you leave. We will have more coming, maybe some Johnny Depp stuff, but make sure to keep me posted on what content you're most interested in. I appreciate you all joining me here. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.